Could I just have a quick word with Mr. Clayton? Mr. Rowe? Mr. Clayton, you promised to give us the 5 missing pages from Mr. Nelson's first opinion.
I have them here.
Well, that's very convenient. Secondly, could we have a copy of the Judicial Review Act, please?
Yes. We'll get one to you.
You will?
Yes.
Very well. Well, let's have those 5 pages straight away.
We've put the whole thing together.
Very well.
Can I explain? Sorry, let me just take 5. 1, 2, 3.
Just while my friend is counting the pages, if it helps, the relevant bit, I suspect, of the Act is at page 1115 in our case.
Okay,
Thank you.
Take off.
Yes, I was pretty sure I'd seen it somewhere.
So where is it?
So, Mr. Rowe, you're saying we don't actually need the whole Act?
Well, it depends which bit of it your Lordship had in mind when asking for a copy of it. But if it was the list of grounds of judicial review, then that's the bit.
I think
That's what I was looking for.
I've been caught out by simply looking at a subsection. And speaking for myself, I would like to look at the whole Act. So please, within 24 hours,
We should get
the Act.
Yes.
Very well.
May I just briefly explain something in case the numbering suggests this isn't the incomplete opinion, but it actually is.
I see. Very well. Thank you, Mr. Clayton. Now, Mr. Rowe.
My Lord, thank you. I think before the short adjournment, your Lordship left me with a question about the document that we looked at from the attorney. Can I postpone my dealing with that to the context, to the general context of the facts of the
Of course.
the matter, and come back in due course on that? Because I wanted to start off with the question of the test to be applied in cases such as this. The starting point ought, in my submission, to be the Act itself, for fairly obvious reasons. One finds that, you'll recall, at the beginning of the authorities bundle. On the electronic pages, it's 122 is where it starts. You've been shown already section 32 that we looked at before the short adjournment. I was going to look at section 35 as well, but I think that's probably been, for present purposes, sufficiently looked at. But what I wanted in the context of the test to ask the board to look at was what it says at section 23. Find it 1146 if you're following on the computer. This is important because this sets up the structure of the Act as regards requests for access to information under it. You'll see that it says where, in relation to a request for access to a document of a public authority, a decision is made under this part that the applicant is not entitled to access to the document in accordance with the request, or that the provision of access to the document be deferred, or that no such document exists. The public authority shall cause the applicant to be given notice in writing of the decision, and the notice shall, they have to do various things, state the findings on a material question of fact, referring to the material on which those findings were based and the reasons for the decision, name and designation of the person giving the decision, etc., etc. And then letter D, importantly, inform the applicant of his right to apply to the High Court for judicial review of the decision and the time within which the application for review is required to be made. Finally, a provision about the Ombudsman in cases where the answer is the document doesn't exist or we can't find it. And that's important because that does make plain on the face of the Act, in my submission, that your remedy, if you don't like the fact that a public authority has refused your request for access to a document, is to seek judicial review. It's right to say, I think, as well, that there is provision that one can approach the Ombudsman as well, but nobody suggests that that gives rise to a binding finding against the authority, or that or indeed that it's wrong to bring judicial review unless you do that first, which is an argument that one might perhaps in some contexts see. The starting point as regards the question of what the test is, in my submission, is the face of the Act. That very strongly suggests that the test is judicial review, so that all of the usual grounds of judicial review are likely to be brought into play.
But sorry, just on that,
yes.
Judicial review can cover lots of different tests. So, for instance, we in the UK have judicial review, for instance, of the proportionality of decisions. under the Human Rights Act, where the court is the ultimate judge of proportionality, even though it has regard to what the decision maker said or did. So I'm not quite sure how far this point gets you.
Well, it gets me this far, my lord, that is that one is starting from a remedy which certainly conventionally has been regarded to be a remedy which imports questions of rationality, reference to relevant factors and so on and so forth. I accept, of course, that in some contexts, in some jurisdictions, such as England and Wales, and no doubt other jurisdictions too, the particular circumstances can mean that even a court performing a judicial review function gets into the merits. I entirely accept that. But certainly, the starting point is that nothing in the Act tells you that that is to be the case. It's true, of course, the Act does talk about, and my friend emphasised these points very significantly, the Act talks about the importance of the general principle of access to information and so on and so forth. But that doesn't answer the question as to what the approach of the court should be when the court comes to consider an action for judicial review in relation to a refusal to supply information.
Yes, and while the Judicial Review Act, as far as I remember, and you've set out grounds, you set out Section 5.3, it sets out conventional grounds. I think you're correct in saying that it is non-exhaustive.
It's a non-exhaustive.
So we can't. There's no simple saying, well, it's not one of those grounds, therefore there is no scope for a wider judicial review. You accept there could be a scope, but you say there's nothing to indicate a broader approach in this case.
Yes, and the cases in other jurisdictions, such as England and Wales, no doubt other home jurisdictions as well from the present geographical perspective, where the court does conduct a merits-based review, are generally the result of some other factor, such as an act saying that certain human rights ought to be taken into account when decisions are taken, or...
But I mean, on that, I think it is being said against you, both that Section 3 creates a very strong presumption, and indeed the case law from Trinidad, certainly in some parts, seems to indicate that that's a very important right.
Well, I'll look in a moment, I'll take your lordships in a moment to some of the case law, but certainly one needs to keep two things quite distinctly in mind in my submission. One is the construction of the Act and the approach that should be taken by a person who is considering a request under the Act. And the other is the question of whose decision it is. The fact that under the Act it tells you that you have to construe it in a certain way when exercising a discretion under it doesn't answer the question as to whether, when a public authority takes a decision not to release a document and somebody challenges it in court, the question for the court is whether that decision is reviewable on conventional grounds or whether the decision is simply one that the court disagrees with. But on the face of it, my submission is that if the legislature was intending to create a state of affairs where, when the matter came before the court, it came before the court de novo, it would have said so in terms that made that readily apparent. There's no reason for it not to have done that, and we know, of course, that in plenty of other jurisdictions that have freedom of information provisions, that is done, often by reference to different terminology. It could have been quite straightforward. The legislature could have said there shall be an appeal to a court, and it could have spelled it out.
Or an appeal by way of review or something of that.
Yes, or
by way of rehearing.
By way of rehearing, my lord, precisely, yes. It could have said something along those lines. It didn't. It simply said judicial review. And although, of course, it's right that Lord Hodge is right with respect that the list in Section 5.3 of the Judicial Review Act is non-exhaustive, nevertheless, one is primarily concerned in judicial review in Trinidad and Tobago, as in other jurisdictions, with the conventional grounds. Lord, I said it was set out in our case. Perhaps we can just cast an eye over it for a moment. It's 1115, para 26 of our case.
Yes. Because I wondered how far that got you as well. Because if it is an objective test of what's in the public interest, then, and the decision maker gets it wrong, then it would be contrary to law, A, would be an excessive jurisdiction, B, would be a failure to satisfy or observe conditions required by law. So, I mean, you can find pegs or slots. I'm not saying that is the approach, but just It didn't seem to me that this helps very much.
Yes, there's a limit to the weight I can ask your lordships to put on the words judicial review in the Act, and therefore by reference on what it says in the Judicial Review Act, because I quite accept that if there were other factors that led you to say, well, this is a review de novo, a complete rehearing with the court giving its own opinion, then to use the respect, the apposite term that your lordship uses, a peg. You could find a peg somewhere in the Act.
Or it might be something akin to proportionality review, where the court does give its opinion finally, but after taking account of what's been done by the decision maker, so that it's not a very stark bifurcation between who exactly is the decision maker and you only worry about their decision.
It could be that. My submission, my lord, is that it isn't. It is essentially conventional judicial review, albeit, of course, taking into account the circumstances in which that arises, because one can say, well, this is only conventional judicial review, and therefore the principles of irrationality and so forth apply, but the extent to which that bites, experience would suggest, depends upon the context. I mean, plainly, if one's trying to displace some discretionary decision of a public authority about funding, one's likely to be met by the court saying, well, really, that was within their remit, and you really got to show some quite extraordinary irrationality to get home. Conversely, if you're saying, well, this was a rational decision to remove somebody from the jurisdiction to some place where they're likely to be in danger, the court's likely to look pretty carefully at the rationality of that. So that there's a degree to which the context makes a difference, and I, of course, would accept that here the context includes what's said in the Act about the importance of access to information, but it is still ultimately, in my submission, and I'll come on to the cases in a second, a question not of the judge taking a second look at the question afresh, bearing in mind the decision taken by the decision maker, the primary decision maker, but of the judge reviewing the lawfulness of the primary decision maker's decision. And Lord, we get that, in my respectful submission, from some of the cases. May I just take your lordship back to the Maharaj case that your lordships were shown, your ladyship was shown earlier. That's the one behind, I think, tab 16.
You must give us all the electronic numbers.
Of course I must. It's page 1771.
Yes.
The bit that I wanted to go to, at any rate.
Yes, we don't have tabs, therefore
that's
why we need the MS numbers.
I didn't realise that your lordship didn't have tabs. I'll stop talking about tabs in that case, which is of use only to me. Yes, it starts at 1757.
Yes, quite.
This was the passage that my learned friend relied upon, setting out the general principles. And it is important, again, in my submission, to keep the distinction in mind between the way you interpret the provisions of the Act, in other words, what the Act means, and the quite discrete question of whose decision are we concerned with? Is it a fresh decision by the judge, or is it actually a review by a judge of the lawfulness of a pre-existing decision by the person who declined to disclose the document? And one can accept my submission without in any way contradicting any of the propositions that we see set out under paragraph 27. So mandated to interpret the Act purposefully so as to further the policy, purpose and objectives of the Act. Well, in a sense, that derives from the Act itself. The presumption in favour of disclosure, the extent of limitation, the public authority having to prove the exemption invoked to deny access.
Can I ask, are you going to show us an authority which you say says clearly it's a pure rationality test?
My lord, I found one, in fact, which I was actually just about to come on to.
Okay, so I just wanted to know where.
Yes, but I will do. And in fact, it derives actually. It's not in the authorities before your lordships, because nobody seems to have spotted it hitherto. But it derives from my having looked at 27.6, which is on page 1773. The court is permitted to inspect the documents for which an exemption is claimed, to permit it to make its own finding. And my learned friends say, well, that shows you clearly that what must be going on is that the court is making its own determination. The reference is to, footnote 7, is to a case called Jugmohan and TSC, and we've dug that out, and I don't know whether your lordships have got it or whether it could be handed over. handed up to your lordships now. I think it's.
I'm not sure that we have got
I don't think we have. I think it's ready to be handed up. I've supplied my learned friends with a copy as soon as I got it.
Thank you.
Thank you.
Thank you.
This is it's a first instance decision from 2004. And it concerns, it's a decision on a particular request for certain information. But what's interesting about
2006, actually. I think it's 12th of June 2006.
Oh, Your Lordship's quite right. I was picking the date off the case number.
Very well.
That would imply that it got to trial rather quicker than it really had.
Yes.
And, my Lord, the question is dealt with by the court under the heading on internal page 12, under the heading "The Approach of the Judicial Review Court on a Freedom of Information Act Application." 7.1, the applicant contended that the court, in considering judicial review applications in relation to the FOIA, should adopt a merit-based approach in its analysis and determination of whether a document is properly exempt. This court is, however, of the view that there is no need to jettison the traditional role of the supervisory nature of the judicial review court in these applications. And the court must resolve the issue arising in this application based on the traditional tools available to the judicial review court. And then the court goes on to say it's trite that it's not an appeal but a review of the manner in which the decision was made, concerned with the decision-making process. The court then goes on to say, in that context, it's in essence a matter of statutory construction, interpretation of the right of an authority to refuse access to a document under sections 27 and 30 of the Act, which were the bits that were in play in that case. No question of showing deference or respect for the views of the respondent, because not only is there the meagrest form of evidence to justify the denial of access on a public interest grounds, that may be a reference to that particular case. The court, in any event, is ordinarily called upon to rule upon the availability of public interest immunity in the disclosure of documentation. It's true that the court says at 7.4, it says in a fair and effective public law system, policy statements and such decisions, that's of ministers or administrators, must be interpreted objectively. So the court may decide the question itself, paying close attention to the reasons advanced by the administrators for the competing interests. See, that sentence seems to have gone slightly wrong, but it seems to be what's being said there is that the policy statements have to be interpreted objectively. There's reference to the Minister of the Civil Service case. And at the end of that section, the court says, 7.7, in the circumstances, this court must consider whether the respondent, in relying upon sections 27 and 30 of the Act, in refusing the applicant access to document 1, was acting Wednesbury unreasonably or illegally or irrationally or out of proportion to the duty imposed under the Act, and will not embark upon an exercise of dictating or fashioning its own policies and directives to this public body.
Do you have this in electronic format?
We probably do, my lady, yes. I'm sure we can arrange for that to be provided.
I noticed counsel for the applicant.
Yes.
If I may say so, that doesn't seem a crisp statement that it's rationality and only rationality. So, for instance, public interest immunity, which seems to be an analogy which is referred to at 7.3, is,
yes,
of course, a decision of the court, very much like the proportionality example that I gave you before, where the court has regard to what the member of the executive says about the public interest, but it is a decision for the court whether fairness at the end of the day trumps those public interest, fairness in disclosure trumps, yes, those public interest considerations.
Yes. Well, it's perhaps important, my Lord, to be clear about what we're arguing about. It's not put at its highest. I can see one could say, well, this is a matter of pure rationality, and really only Wednesbury unreasonableness in the decision will suffice. At the other extreme, one could say this is a pure appeal, and the court considers the matter de novo, albeit, no doubt, as courts considering things de novo always do, it has at least half an eye on what the decision maker made of it first time round. I understood my learned friend's submission to be really we're at the latter end, and really it's really the court's decision that is made de novo. If that's the submission, then I submit that's wrong.
But it might be somewhere in the middle.
Well, it is a determination in my submission of the lawfulness of the decision maker's decision to refuse disclosure. I can see, without necessarily conceding the point, one can see why it might be said that doesn't limit it to pure irrationality, pure rationality.
Mr. Rowe, I think you've shown us a decision of 2006, and we would want your comments now, going back to the very recent decision of Mr. Justice Rampersad. We would want your comments now on 27.9 that we've got at 1773. Recent case law now establishes generally for the public authority to establish no overriding Section 35 interest. How does that fit with the analysis that you've offered us?
Because at the time that the public authority makes the decision to refuse or permit access to the document, it should make the decision bearing in mind that there is, as it were, a presumption in favour of disclosure. But it doesn't follow from that what the court is saying there is that the question is at large before the court. And that's why, in fact, if one looks at...
Pretty close, it does come pretty close to it.
My Lord,
But,
I agree, and I confess the exercise that I did, I don't know whether that one's in the authorities bundle, I don't think it is, and if it isn't, certainly the exercise that I did in relation to Jugmohan, I didn't do in relation to
no.
the authorities cited, Ravi, Dudnath, Jaipal and PSC.
No.
I mean, certainly, my Lord, if this is, as may be the case, this is going to be an issue which is an important one in Lordship's determination. And
Mr. Rowe, don't you trouble. We will ask our judicial assistants to find that for us after the hearing.
Yes, well, I was going to volunteer to do that exercise, but
No, let them do it.
If they're willing to do it, then even better. And
May I just pick you up on one thing you said
Yes.
there, a presumption in favour of disclosure. I mean, it might be said that Section 3.1 goes rather beyond that. It creates a right of disclosure subject to exemption.
Subject to the provisions of the Act.
Right.
Yes. But that's slightly...
One reason why I raise that with you, so you can deal with it, is that almost looks like the structure of reasoning that you do get in a proportionality case where a human right is an issue, namely right with grounds from which the right can be derogated from. Where, as I've already put to you, in this jurisdiction at any rate, the ultimate decision would be that of the court, although having regard to what the executive decision maker has done.
Well, one can see the similarities of the Act so construed with the regime that prevails in relation to human rights in the United Kingdom. But it doesn't follow, in my submission, from this Freedom of Information Act that the same structure applies. What the Act, if we can go back to it, what the Act actually says, 1126, is that its object is to extend the right of members of the public to access to information in the possession of public authorities by, and then the two things that we looked at earlier, B, creating the general right of access to information, etc., limited only by exceptions and exemptions necessary for the protection of essential public interests. So I accept that that is the object of the Act. But it doesn't necessarily follow from that when a public authority takes a decision about whether a document is disclosable under the Act, a person who doesn't like that decision has an automatic right to ask a court to take its own decision. This comes back to my point that if that's what Parliament had intended, what the legislature in Trinidad and Tobago had intended, it could quite easily have set it out expressly.
But what about subsection 2, where the legislature has given its direction as to how to exercise the discretions conferred by the Act?
Yes, well, that tells you that that's how the discretion should be exercised, but it doesn't tell you that if somebody exercises the discretion and decides not to disclose a document, anybody aggrieved by that has an automatic right to a second bite of the cherry in front of a court.
No, the argument is more sophisticated, isn't it? That is, when the court interprets the level of intensity of judicial review, brackets, it not having been provided by the legislation that it should be limited to judicial review under Section 5 of the Review Act, close brackets, the court has to utilise the discretion in the manner provided for by Section 3.
Well, that I wonder if that isn't question begging, lady, because doesn't that presume that the court is exercising the discretion? The prior question is on whom is the discretion conferred,
yes.
And I submit that the scheme of the Act is that the discretion is conferred upon the public authority as to whether to disclose a document or not.
But it's any discretion. Why doesn't that include discretions conferred on the court?
Well, it would, but one still needs to find what it is that confers the discretion on the court. And the Act itself doesn't do that. It expressly says that what the right you have if you don't like a decision is to apply for judicial review.
Yes.
Which, though I agree, doesn't exclude necessarily the possibility of the court taking its own decision ultimately, is certainly conventionally understood as a review of the lawfulness of the decision on conventional
Yes, are you
grounds.
taking a distinction between conferred by this Act as opposed to conferred pursuant to this Act?
Am I taking that distinction? Well, I'm not sure that I am, my lady. My point is that simply saying that any discretion conferred by the Act has to be exercised so far as possible in one direction doesn't answer the question as to what the nature of the exercise is when a court is called upon to...
But it does have, it's a factor when the court decides the level of intensity of review, that it is this mandate and obligation.
The level of intensity of review is generally, I would submit, altered by the circumstances of the case, the outcome, and that's perhaps it's a fairly trite point, but that's why review is much more intensive when the question is, should somebody be put on a plane to Afghanistan compared to should some decision to spend some public money be reviewed.
That must be so in relation to a public authority, where the nature of the decision may be that the capacity of the court to review it is somewhat limited because it depends on technical expertise which is not available to the court and only within the remit of the decision maker. So it looks as if the level of intensity of review may have to vary according to the context.
Well, lady, that's always the position, and whenever a court is called upon to exercise a judicial review function, whether in the sort of narrow old-fashioned sense or perhaps in a more modern sense that crops up in human rights contexts. But one still needs to keep the point firmly in mind. I suppose the point I do seek to defend is that it's not a de novo hearing before the court.
Yes, well, I mean, Section 39(1) is quite interesting in this regard because it opens with the words "for the removal of doubt." So it may be questioned whether the Act is conferring any discretion on the court rather than just confirming that the general law contains a right of judicial review against, in relation to the decision of public bodies, and we must look elsewhere for the outside Section 3 for the scope or intensity of the review.
Yes.
Mr. Rowe, very quickly,
yes.
If you've still got the recent decision in front of you, 27.
Yes.
2713, quote from Justice of Appeal Jamadar in the construction industry case. Thus, when one comes to the evaluative exercise demanded by Section 35, both the public authority initially and the court of review subsequently are obliged to carry out. Can you help us on that?
Yes, my lord. That's one statement by one learned Justice of Appeal in that case. That was the case in which, in fact, the judgment of the court, I think, was that the authority had not at all considered the Section 35 criteria. That was that's stated in the, I think, in the other judgment. Give me 1 second. Yes, that's in Justice of Appeal Barrow's judgment, page 1838 at paragraph 75.
Yes, but I don't think that part of the reasoning formed part of Justice of Appeal Jamadar's decision, did it?
It doesn't appear to, but one might make the other point, the point the other way, which is that equally there doesn't appear to be anything leading up to the suggestion, which is very much sort of en passant, that the court has to re-exercise the discretion effectively. I mean, it starts with the word thus, but in fact, if one goes to 1865 and reads back what it is that thus refers to, it's about the importance of the right of access to information. It's about the constitutional elements of this, active participation in public affairs and so on and so forth, none of which quite gets to the point about whether or not it's for the court to take its own decision or whether the court is acting as a court of review.
Just on that, if I may, just since we're looking at section 3.2.
Yes.
In fact, there are two limbs to that. My lady asked you about the second limb, about the discretion, but the first limb is the provisions of this Act shall be interpreted so as to further the object set out in subsection 1. I just wonder whether it might be said, again, against you, that since the object in subsection 1 is to allow for transparency and observation of the actions of the government, and we've seen all the judicial pronouncements against secrecy,
yes,
whether that first limb of section 3.2 has a tendency to indicate that the court ought to be exercising, if not a completely de novo, at least an intensive form of review, because otherwise you're just leaving the secrecy decision on the, essentially, the ipse dixit of the government itself.
Well, yes, one can see the force of that point, but one oughtn't to press it too far. In my submission, it's difficult. In a sense, it's difficult to deal with in the abstract because, and that's illustrated actually in some of the cases that your lordships were shown earlier on by my learned friend. Because in a case where you can see that there really hasn't been any proper consideration of the considerations that need to be considered under the Act, then, of course, in those circumstances, the court will review the matter more intensively. But conversely, in a case where it's been expressly addressed, then the fact that the Act should be interpreted in that way doesn't necessarily mean that the court should go any distance down the road towards being itself the primary decision maker in relation to the question as to whether the document should or shouldn't have been disclosed. I mean, these are all these arguments about what Section 3 means are all arguments where one is having to have. They're all arguments one's having to have because the Act itself doesn't say what the Act could quite simply have done if they'd wanted to, which is just to say any decision can be reconsidered de novo by a judge. But of course, I can entirely see the force of the point that one might have difficulty in defending a completely hands-off approach on the part of the court.
Now, we've been bowling a number of questions at you.
Yes.
You may have been taken slightly off your plan, and I think we should respect your wish to continue with your submissions.
Well, that's my last.
We won't enter into a self-denying ordinance about further questions, but we will be cautious because you must be allowed to say what you want, Mr. Rowe.
Well, that's very kind of you, though. My plan was to answer your lordship's questions, so I'm not unduly upset about it, but I'm grateful to your lordship for that indication, and I shall try to move on a little. My lords, I think I've probably said everything I can usefully say on that subject. May I just check for one moment that I've,
Yes, of course.
in the flurry of questions, not overlooked anything terribly important that I was going to try to interest your lordships in by way of further authority. No, my lord, I think that's probably enough on that subject. May I then go to the facts, which I know will be relatively familiar to the board, but from reading and from my friend's submissions already, but I wanted just to highlight a few of them. It's perhaps slightly beguiling to think of it in terms, or self-beguiling, to think of it in terms of the government having a claim for $97 million if one keeps in the forefront of one's mind the $97 million. The important emphasis in that sentence might be said to be that the government had a claim, was making a claim for $97 million. And I wanted just briefly to take your lordships to that claim, so as to see the context in which these suspicions are alleged to arise, because before I get there, I wanted to illustrate, set out really what I mean by that. The proposition, as it's put by my learned friend, is really that it's simply obvious that access to these witness statements was something that was in the public interest, and was overwhelmingly in the public interest, or at least arguably so, for the purposes of the permission test, the leave test that we're concerned with, because of suspicions, concerns about what had gone on. And your lordship perfectly probably took me earlier to the letter, which showed that it wasn't just a particular hobby horse of the appellant, that there were some concerns. Others shared the concerns, and one can perhaps see that. But one needs, in my submission, to focus on the relationship of the concerns to the document. It's no good saying because there are suspicions and concerns about something that's happened in the public sphere, anything which is in any way remotely relevant to that by way of information or document is disclosable ipso facto under the Act. One needs to tie it more closely to it, in my submission. I accept that is not spelled out in the Act, but that is, in my submission, implicit in its structure. And can I, just before we go to the facts, but very much closely in connection with that, just ask your lordships to look again at the provisions of Section 35 that we're really concerned with primarily, which is at the beginning of the authorities' bundle.
Page 1158. 1158.
Yes, 1158 gives us Section 35, the rightly described as the override. And as I said earlier, this must logically apply to documents which it's already been determined it is contrary to the public interest to disclose, because it applies to Section 32 documents. So it's a slightly paradoxical idea that you can have a document which is contrary to the public interest to disclose, but which is nevertheless in the public interest to disclose. But the only way that it can be squared, perhaps, is by saying that it's contrary to the public interest in some respects that it be disclosed, but the overriding ultimate balance, as far as the public interest is concerned, is that there should be disclosure. It's not surprising in those circumstances that it's relatively stringent in terms of what needs to be the case before a document which is otherwise exempt nevertheless has to be disclosed in the public interest. And although we're not now concerned with the first limb, it's instructive in my submission to look at what the first limb requires. There needs to be, a public authority shall give access to an exempt document where there is reasonable evidence, so not suspicion or concern or public anxiety, but reasonable evidence that's significant, so nothing trivial, but something significant. And then various things exist: abuse of authority or neglect in the performance of an official duty, injustice to an individual, or danger to the health or safety of an individual, the public, or unauthorized use of public funds has or is likely to have occurred. So that condition sets, I submit, a fairly high bar, unsurprisingly in circumstances where it's already been determined, ex hypothesi, that this is an exempt document whose disclosure would damage, that is exempt because its disclosure would damage the public interest. And then you get the second condition, or in the circumstances giving access to the document is justified in the public interest, having regard both to any benefit and to any damage that may arise from doing so. And as I think we pointed out in the case, when the Act was originally enacted, those were actually cumulative conditions. So it had to satisfy one or more of the A to D conditions, and it had to be such that in the circumstances giving access was justified, etc., etc. But the Act was fairly rapidly amended so as to substitute for the and, the word or. So I accept that they are different conditions, and one or other would suffice. But something of in my submission, something of the flavour of what you've got to get to in in the second condition does, on ordinary principles of construction, derive from the first condition. Except, of course, it may be said, well, yes, but look at other parts of the Act which we've been looking at that give rise to a broad duty to disclose, but nevertheless there is room for, in this context, the conclusion that the circumstances giving access, the circumstances in which giving access to the document is justified in the public interest, having regard to the benefit and the damage, need to be something fairly serious and significant, and if not quite eius gem generis with everything else that's before, at any rate, at least broadly, I would submit in the same sort of territory. That requires one, if one's looking at condition 2, as I've called it, or the second condition, which it seems to be common ground now we are, to identify not only a general sense of unease about some particular aspect of public administration, but some reason why the particular document which is targeted is one that ought, in those circumstances, to be disclosed. My Lord, it's with that thought in mind that I wanted to go briefly, or take your Lordships briefly, to some of the underlying facts, and to the claim that was made originally against Mr. Jones. And can I pick it up from the statement of claim, which your Lordship should have in Volume 1. I think begins,
page 106 it begins.
Yes, I thank you, my Lord. Page 10. Yes, it does begin at 106. Statement of case, forgive me, is how they're described in this jurisdiction. And you get the general overview that I think your Lordship has already been invited to look at. And the breaches of duties are set out on page 140. And we can see that what is said is that Mr. Jones, who was at all times executive chairman of Petrotrin, was in breach of his Section 99 duties and or his common law duties as set out above. Section 99 is a series of codifications of the usual duties of directors. But in fact, although there's been some suggestion from time to time, I think from recollection, I couldn't put my finger on it now, that we're concerned with fiduciary duties, but in reality we're concerned with duties of care, if one looks at the pleadings.
Yes, but Section 99, I think, covers both, doesn't it?
Yes, it
covers the strictu sensu fiduciary duty, but the duty of skill and care that's imposed on a director.
Yes, it's akin to the section, wherever it is, 170, around about, of the UK 2006 Act. But if we look at what he's actually alleged specifically to have done wrong, no director and executive chairman exercising care, diligence and skill, so that's the duty we're concerned with here, would have executed the joint and several guarantee in the light of the warnings set out above, and that's a reference to some warnings that are said to have been given about the joint and several guarantee that was given to the joint venture partner in the project. And further would not have executed a joint and several guarantee in the light of those warnings when the company was unable to exercise any effective control over the cost of construction of a major project such as the GTL plant. And then the second one is that he failed to, and this is pleaded as a direct breach there and then, as it were, he failed to direct and or procure the management and or legal advisors of Petrotrin to ensure that prior to or simultaneously with the execution of the guarantee, the shareholders' agreement was renegotiated and amended to provide for Petrotrin to assume management and or control of the construction of the GTL plant in the event that it should be called upon to advance any funds pursuant to the joint and several guarantee. If Petrotrin had been entitled to exercise such control, it would have been in a position to mitigate its obligations under the joint and several guarantee by abandoning the project and or placing its own personnel, etc., in place. In other words, it could have taken over the project and mitigated its losses by running it better than the joint venturers, for whose liabilities it was now accepting responsibility, were running it. Failed to ensure that prior to the execution of the guarantee it obtained its own flexibility and cost study, executed it when Petrotrin had no control of management, caused or procured Petrotrin be a party to undertake obligations of guarantee of the entire costs of construction in circumstances where Petrotrin had a minority interest. And then there are various further allegations set out at F, all of which are said things that were done that were contrary to the interests of the company. G has failed to carry out due diligence. And then, in fact, the only fiduciary type breach is right at the end, H, which is failure to disclose his own breach of duty as set out above, on the basis that as a fiduciary you have to disclose your own breaches of duty. Query whether it's a fiduciary obligation to disclose your own negligence as opposed to breach of fiduciary duty. But anyway, that's what's alleged there, and it said he should have obtained legal advice as regards his breach of duty. It's only actually properly spelled out at 59A, but actually all of B to G are not, although it's pleaded in terms that it was a direct breach of duty to do X, it's really the plea is you fail to exercise or should have been, it's a failure to exercise the skill and care reasonably to be expected of a director exercising reasonable skill and care in the performance of his functions. Mm-hmm. So it's clear negligence rather than a breach of fiduciary duty. And that, of course, that's important in terms of thinking about the idea, if one were tempted to do it, that the government simply had a claim against him, as it almost a right against him to recover this money. The government would have had to prove in this action that he had fallen below the standard of care to be expected of any reasonable director exercising reasonable skill and care. And Mr. Jones didn't exactly roll over and say, yes, that's fine, I put my hands up to that. He put a defence in, which is in the record as well. And can I pick that up, my lords, at page 339? Paragraph 22, in early 2006, the various parties, including Petroleum, the claimant here, were collaborating in arranging finance for the project. Various finance proposals were requested. Last sentence of that paragraph, which is over the page at 340. During discussions with bidders, the issue was raised that as a condition precedent to the granting of the loan, the sponsors have provided joint and several guarantee. 23. The claimant's board of directors, of which the defendant was but one member, suspected that WGTL might have been unable to reimburse the claimant if the claimant were called upon to honour a joint and several guarantee on behalf of both sponsors, but the board of directors were of the unanimous opinion that the risk of WGTL Inc. failing to bear its portion of the cost was outweighed by the attractiveness of the construction of a gas-to-liquids plant and significantly addressed by the implementation of the guarantee contribution agreement, dated 12th January 2007.
Mr. Rowe, why are we going into this degree of detail? We've got two very eminent senior counsel in 2011 agreeing that there was a prima facie case of negligence in respect of the 2007 guarantee. I mean, are you seeking to persuade us that that was wrong?
No, but I'm seeking to head off any suggestion, and perhaps your Lordship's question indicates I don't need to, that this was anything other than a contested action which depended upon Petroleum proving something which is not on the face of it obvious that it would necessarily be able to prove. I mean, I'd go no further than that. I can't invite your Lordships to form any view about what the merits of the case might have been had it fought.
Thank you.
But I do this just to emphasise that context. And bearing that admonition in mind, can I take your Lordships very briefly to page 356? This is answering something which was said in the statement of case of Petroleum about the suggestion that they had been panicked into entering into the joint and several guarantee. This is denied at 66B. The project was at a critical stage immediately prior to October 2006, and the claimant's board of directors has been waiting for official confirmation, etc., etc., etc. And so in that context, it is denied. And then they were panicked into making this decision. And over the page, 68, the claimant's board of directors did approve the signing of the joint and several guarantee in their meeting of September 27, 2006. That approval was based on the board's reliance in good faith on the report of Mr. Wayne Bertrand, etc., which formally recommended to the board they approve the execution of the joint and several guarantee after the new technology was found to be viable. and they did decide to enter into the guarantee. I'm not going to go any further than that, but I rely upon that material simply to illustrate my point that this was a contested action in which it was certainly, there can be no suggestion that it was a straightforward knockout win for the government was on the cards in any circumstances. On the contrary, the government, Petrotrin, not the government, Petrotrin had to prove something which is not altogether easy to prove, namely failure to fall below the standard of any reasonable director exercising reasonable skill and care. And that is the context in which the advice from Mr. Nelson, Queen's Counsel, comes in immediately prior to the decision to terminate the action. Your Lordships have been shown that advice already. It's at page 547 in Volume 2. He deals with the disclosure question first of all, which in fact we can see from the introductory paragraph is what he's been asked to advise about. But he then seemingly takes it upon himself at paragraph 6 to address the merits.
Have we got
of
his
the
instructions for this advice?
I don't think we do have his instructions.
Very well. Yes.
You can see from one, he says, I've been asked by the instructing attorney in this matter to prepare a note of advice to the board in relation to the company's duty to make disclosure of witness statements. And he attaches the earlier advices. And your Lordships have read already the critical passage at paragraph 6, where he says he's considered the contents of Charmaine Baptiste and Anthony Chan's witness statement not available in 2011 when the advices were rendered. Having considered them carefully, there is a basis for concluding that the Petroleum Board, through bad business decisions, found itself committed to the GTL venture with WGTL Inc. The board was naive and probably duped by WGTL Inc. principles. Once the board discovered how deeply committed Petroleum had become, appears from the witness statements of the two directors, the company did what they could to protect Petroleum's assets.
Was there any arguable force in the point I raised with Mr. Clayton about that? Once the board discovered how deeply committed Petrotrin had become, the witness statements show that the company did what? How could that bite on the nub of the claim referable to entry into a guarantee in January 2007?
Because the guarantee wasn't the first thing that happened in the joint venture. The joint venture was already underway when, in order for it to continue, there was pressure put on Petrotrin to enter into the guarantee.
So you say once the board discovered how deeply committed Petrotrin had become, that is referable to a pre-2007 situation.
That is as I would invite the board to read it. Yes, referable to the fact that the joint venture was already up and running to some extent at that stage. This wasn't a case. The joint and several guarantee wasn't the first thing that happened.
So the guarantee was entered into after Petrotrin had become deeply committed.
That's what counsel appears to be saying, and that would appear to be consistent, as far as one can discern it from the pleadings, with what Mr. Jones was saying in his defence.
Yes, but are we to take this paragraph as meaning that he has interpreted the witness statements and taken the various things that he here lists from them? So from the outset, he's saying the sentence before the one that Lord Wilson refers you to, presumably is talking about the situation at the outset, the naivety and being duped. And then...
it's not entirely clear, my lord, but the complaint in the proceedings, of course, is about entering into the guarantee.
Yes.
And one assumes, therefore, that what's being referred to by the board being naive and duped is that it was being naive and being duped that caused the board to enter into the guarantee.
I mean, the public has been given this opinion. You say it's not entirely clear. Would the witness statements help to make it clear?
My lord, I'm not sure I could answer that question without having read them, which I haven't. But because I haven't seen them any more than anybody else has seen them.
Mr. Rowe, that's a very neat answer.
Well,
Let's continue.
The question, this does rather go to the heart of it, my lord, which is how far does this go? Because it's one gets very strongly from the affidavit and indeed from the passage that your lordship took me to earlier, the suggestion that this was something other than a decision in good faith, that on reflection this claim is not really quite as good as we thought it was. Now, the suggestion that the claim on reflection is not quite as good as we thought it was is, in fact, it would seem, I would submit, and it seems from the material that we've seen, a not entirely surprising one. It's true that there were two earlier opinions from counsel that said this was a good claim, but it would hardly be the first time that counsel had advised at the outset in relatively gung-ho terms, and then subsequently things had emerged which had led counsel to take a different view.
Well, the evidence is emerging. I mean, the evidence wasn't available at the outset, so...
sorry, my lord?
These two witness statements were not available at the outset when the first advice was...
Well, my lord, that's right.
Yeah.
That's right. But the point is really, if... This is why I said earlier, clearly if the government... A lot of the cases you were looking at, were about refusal to disclose legal advice. If a politician who may or may not be in a position to control a state entity says, well, I've decided not to pursue this $97 million claim, but I'm not saying why, one can see why people get concerned about that. If he says, well, I've done it on the advice of counsel, but I'm not showing you counsel's advice so you can establish whether I'm right about that, one can see why people might be concerned about it. But here, he says, I've done it on the advice of counsel, and he produces the advice of counsel. And really what the gist of it seems to be, well, does the Act go so far, in the context where it's common ground that disclosing the witness statement damages the public interest, does the Act go so far as to enable the applicant and anybody else who's like-minded to satisfy his curiosity as to whether Mr. Nelson got it right? But that's a completely different issue from talk about suspicions that something untoward went on, in circumstances where it is not suggested that Mr. Nelson did anything improper. One may or may not think that his advice is a strong advice or a less strong advice, but it's in terms of what it ought to have covered, and your lordship made the point about this being a $97 million claim, and perhaps lots of lawyers would say, well, if I were asked to advise on a $97 million claim, I might give slightly more detail than was given in that advice, or rather more detail than given in that advice. But the fact is that's how it was done, and he gave that advice in clear terms, and that dispels, in my submission, any suggestion that that the Attorney General was not speaking the truth when he said it was done on advice. And more pertinently than that, because it's no part of my task to dispel those suspicions. People are perfectly entitled to have those suspicions if they want them. But for present purposes, would disclosure of the witness statements give rise to some discernible public benefit, such as to outweigh the admitted public disbenefit that we've looked at by virtue of the circumstances in which the information was given? That was the question, and it's really, whatever one might think about the ultimate burden of the argument, it is incumbent upon the appellant to produce a clear articulation of why it is that you need to see these witness statements in these circumstances, in circumstances where we've got counsel's advice that is absolutely clear. So, my lord, in those circumstances, one has that advice, and the question that, as I say, needs to be tackled really is whether the witness statements are documents that need in the public interest to be disclosed, and I submit that the decision of Petroleum to the effect that they did not is and was a perfectly lawful decision. In any event, it's been looked at in detail by the judge, and we'll come on to that.
You say need to be disclosed. Is it need to be disclosed or need not to be disclosed?
By the time one gets to Section 35, need to be disclosed, because the sequence is they need to be disclosed because they're documents and the public authority has them.
You get the exemption under 32,
yes,
and you get the override under 35.
Yes. So once we're at the stage of the override, the question is should the public interest in their not being disclosed be overridden by some greater public interest? And if so, what? And that's where, in my submission, the appellant's case on the facts really breaks down, because at no stage in the claim have we had a clear articulation in my submission as to what it is really, other than the understandable curiosity on some people's part, no doubt, that gives rise to this override. So, my Lord, that's the context in which the request is made. Can we just look briefly at the decision letter? I know Your Lordship's already seen it. I didn't, by the way, read out expressly, but I'm sure Your Lordships have it, the ultimate conclusion of Mr. Nelson, but he says in terms, there is a reasonable likelihood that a judge will be persuaded that there was a bad business decision but no negligence. So that's pretty clear advice from counsel that was being given to Petrotrin. The decision letter is at 716, volume 2.
Could I just ask one further question about it? Mr. Nelson's advice starts off by saying that he's being advised to, asked to give advice about disclosure of the witness statement.
Yes.
And then he concludes on a different matter, which is the prospect of the litigation succeeding. It's a somewhat unusual opinion.
It is unusual, I suppose, my Lord, in that respect, but, well, is it unusual? I'm not sure. I mean, counsel's obligation is to, there are plenty of cases about this in professional negligence context, aren't there, about what a lawyer's duty extends to, and if in the course of considering the question as to, whether or not there should be, or rather the disclosure, or rather what the response should be of Petrotrin to the request for disclosure in the proceedings, if in the course of thinking about that, counsel has another look at the documents and thinks, actually, crumbs, that rather affects my view of the merits, then he's probably bound to say so, I would have thought, as a matter of his discharging his duty to his client. So I mean, I agree, it's perhaps not, it's not the commonplace advice where you say, I've been asked to advise on issues 1, 2 and 3, and here are my views on issues 1, 2
Because this was after the event, was it, or was this before the abandonment of the litigation?
This was before the decision to abandon the litigation. Yes, there's a chronology set out in the, well, there is the chronology as you'd expect there to be, which is volume 4, page 1069. I'm grateful to my
Mr. Rowe, 2 days before this opinion was written, was a Minister of Communication for the new government saying that the case against Mr. Jones was heading for dismissal?
There's reference to that. May I just pick up the reference to that?
Yes, certainly.
Give me a second. I'm so sorry. I don't think it's 2 days before that. I think it's actually a little longer before that, my Lord. The advice from Mr. Nelson is dated the 11th of October.
Yes, I've got the Minister of Communications down as the 9th, but
oh, no, you're quite,
I may well be wrong.
My Lord, you're quite right. It is the...
So what was the government, why was the government floating possible dismissal in advance of receiving this advice?
I don't know.
No. Very well.
Yes, Your Lordship's, just for the reference, Your Lordship's referring, I think, to what's said on page 41, volume 1.
Thank you.
Minister of Communications, Mr. Maxine Cuffin.
Yes.
As far as I'm aware, the case against Professor Julian exploded in the High Court and was dismissed with the Attorney General. In the case of Mr. Jones, I think the matter headed in that direction. But, my Lord, nobody suggests, and quite rightly it hasn't been suggested, and it couldn't be done unless it was properly and distinctly done. Nobody suggests, to put it completely crudely, that Mr. Nelson was put up to writing this opinion. So the inescapable fact is that when Petrotrin passed the resolution to conclude the case, and when it served its notice of discontinuance, it had in its possession Mr. Nelson's advice saying that there is a reasonable prospect that you will lose.
Yes.
So that really deals in my submission with the suggestion that one needs to see the witness statements. The witness statements, the only reason for needing to see the witness statements, logically, would be to see whether Mr. Nelson had got it right, but that's a different issue from whether this was a political decision taken in advance to abandon the case. That won't be answered by looking at the witness statements.
But might it not be a ground of criticism of the Attorney General that perhaps the Attorney General has relied on exceptionally weak legal advice in deciding to drop the case? And if one looked at the witness statements, you'd see just how weak the advice was.
Well, my Lord, there's a limit to the extent to which speculations like that, in my submission, ought to be permitted to trigger the Section 35 override. I'm not sure I can take it really much further than that. When one recalls recalls that Parliament in the Section 35 override required under the first limb there to be reasonable evidence of significant abuse of public position, etc., etc. And I agree the second condition doesn't put it in quite such stark terms, but my submission is it's likely to be the same sort of territory. Then a speculation that the Attorney General is to be criticised for having relied upon weak legal advice and that should be cross-checked by reference to the witness statements may bear rather less weight than if one were in a case where the suggestion were that it just wasn't true that he'd had legal advice and he was refusing to disclose the advice that explained whether he did or not. That's really, I think, as far as I can take that. My Lord, I was looking at inviting your Lordships to look at the decision letter. That's volume 2, page 716. Mr. Stevenson, the designated officer who determines this request, refers to the documents that are sought, the judgment, as it's described, the award, in other words, and the witness statements. The first request is granted. The reason for the first request being granted, that's to say the award is explained at the top of 717. The award is already in the public domain, so Petroleum is able to disclose the same to you. As regards the second, the witness statements that we're concerned with, there's the explanation given as to why Section 32 is thought to apply, which is now not challenged. So the section is set out. If in the middle of that paragraph, if witnesses who have given witness statements in confidence are to have those statements disclosed, future potential witnesses would not be willing to keep such evidence. Arbitration proceedings are confidential. Arbitration court which receives witness statements given in confidence will not in future be willing to provide arbitration services to Petrotrin. Second, disclosure sought, if granted, is likely to destroy the usefulness of the rules of the London Court of International Arbitration as an alternative form of resolving disputes to the Supreme Court so far as Petrotrin and similar state entities of Trinidad and Tobago are concerned. Further, the agreement of Petrotrin and such state bodies in the conduct of their business would be greatly reduced, if any value. These were the sort of things that we were discussing before the short adjournment, I think, or perhaps just after the short adjournment. It would amount to a divulgence of information contrary to the provisions of the LCIA, which govern the arbitration in question, as reference to Article 30. I don't accept my learned friends, and invite your Lordships not to accept, more importantly, my learned friends' suggestion that it's just flat wrong to refer to Article 30. Article 30 is the one at page 738, which does contain the undertaking by the parties as a general principle to keep confidential all awards together with all materials in the proceedings created for the purpose of the arbitration and all other documents produced by another party in the proceedings, save and to the extent that disclosure may be required of a party by legal duty to protect or pursue a legal right or also challenge an award in bona fide legal proceedings before a state court or other judicial authority. So they were right that there was a prima facie obligation of confidentiality. Of course, as we've discussed, it could be overridden, but that doesn't mean that it's not a prima facie obligation.
Well, yes, the parties could have agreed that if there was a requirement for disclosure under FOIA, it would happen.
Yes.
It was a failure to take the step to get that agreement at any stage.
I agree. The parties, I suppose, could insert such an agreement into such a clause into their arbitration agreements, but one might be back if that happened in the same difficulties that we discussed earlier about whether people would be willing to arbitrate in those circumstances, in what might be sensitive commercial disputes. I mean, I know it's a subject, of course, of great great debate in academia and generally as to the extent to which it's right for arbitrations in some contexts to be conducted in private, and particularly where it's a state which is arbitrating rather than two private individuals whose affairs really are their own business. Of course, there are debates about the extent to which that's the case, but the fact is that this arbitration was conducted under these rules where it had been agreed that everything would be kept confidential, and that would be absent some fundamental shift, some sort of paradigm shift as to states entering into arbitrations. That's the position that prevails.
Yes, and there's nothing in Article 30 which says merely because there is an FOI request, therefore the confidentiality that the parties have agreed upon flies off.
No.
That confidentiality remains on one side of the balance.
My Lord, that's right, and with respect, and that relates perhaps to a point, since I think of it when Your Lordship mentions it, I ought to deal with it before I forget, that my friend made quite a lot of the fact that we were at the ex parte stage, we were at the leave stage in the present case. But his submission came quite close to saying, effectively, because at the leave stage it's ex parte and there's no evidence from the respondent, more or less in every case the court has to allow the disclosure to be given because there's nothing on one side of the balance. But of course the court can perfectly properly take into account factors which are apparent from the evidence before it, even if that evidence is given by the applicant for judicial review.
Yes, so they can look at the court at the leave stage can look at the applicant's evidence, the affidavit, and they can look at the decision letter, because that's the respondent's evidence, as it were.
Yes, effectively, that's the respondent's evidence.
Yes.
It's not put in formally under a respondent's affidavit or witness statement, but
it is the reasons for their decision.
It is exactly, it's the reason for the decision.
It hasn't got to accept the opinion of counsel as disposing of the issues, has it? It could say, well, that's all very well, but there is still an inference that there's reasonable evidence of misconduct, notwithstanding counsel's opinion, or because of.
Does Your Lordship has in mind what Mr. Nelson's advice? Yes, of course the board of Petroleum did not have to accept Mr. Nelson's advice, but the general mischief which is hinted at as being the most, which is not hinted at but referred to as the most powerful reason for the disclosure to be granted is the suspicion about what has gone on, and that's not a suspicion that there was a mistake on the part of Mr. Nelson and that the Attorney General was negligent in adopting that and not spotting that mistake. It's pretty plain. It's something rather more serious than that.
Yes.
That's why I say, well, that's really disposed of by providing Mr. Nelson's advice.
Well, surely, if the allegation is of the nature you've just described, the opinion is not an answer. If it can be inferred to a sufficient degree that that Petroleum released the cause of action or abandoned the cause of action for an improper reason, then the opinion is neither here nor there. It's more like a smokescreen.
Well, one has to keep in mind what is being sought. The witness statements are being sought, and the reason the witness statements are being sought, it seems to be because that will somehow test the opinion of Mr. Nelson. But that doesn't answer the question as to whether or not there was some overarching impropriety in all of this.
No, well,
Mr. Nelson's opinion was simply a smokescreen.
But, Mr. Rowe, when the board was asked to consider a decision as to whether to withdraw from the proceedings, isn't it unlikely they would just have been given the opinion of Mr. Nelson? They would have been given a briefing as to what the reasons might be for withdrawing, and no doubt if counsel's opinion was dependent on particular documents, they'd be given a summary of those documents. Isn't that a reasonable way to expect a major international company to operate?
Some might and some might not, my lady. It's not.
If
I can break that down a tiny bit, if the suggestion is that there are some other documents, some other briefing or something which would have been given which hasn't been disclosed, well, that can be made the subject of a separate request. We are concerned only with the request to see the witness statements,
Indeed.
But there's no particular reason to think in my submission that the decision of the board will have been taken on the strength of looking at the witness statements themselves or some other summary of their contents other than what Mr. Nelson said. The probability is that I would submit that they looked at advice of this extremely senior counsel and said, well, if counsel thinks that, then...
And nothing else?
Well,
that wouldn't...
I mean, your ladyship and I are both speculating as to what...
I'm not speculating, I'm just saying a reasonably competent board would surely ask for a proper briefing from the company secretary or whoever prepares the board papers. It's not a decision to be taken lightly.
Of course not, my lady. I see that entirely. But all of that, to some extent, in my submission, does miss the target of going for the witness statements, the purpose of which really can only be to test, I submit, whether Mr. Nelson's advice was right or wrong. But since it isn't suggested that Mr. Nelson was put up to writing an advice which wasn't supported by the witness statements, it's hard to see what public interest is advanced by the disclosure to the public of the witness statements. Yeah. Going back to the decision letter, we then get the express consideration that is given to, well, I should just pick up at the top of that page. We get section 32(1)(b) and the decision that's taken there, now unchallenged, about the applicability of section 32(1)(b). And then we get the express consideration of the overriding general public interest considerations at section 35. This is the provision that some of the earlier decisions you looked at, that in some of the earlier decisions we looked at, the decision maker had overlooked, but it wasn't overlooked here. Having regard to any benefit and to any damage, etc., it's not justified in the public interest. Damage would be done if the public interest to encourage litigants to settle their differences utilising alternative dispute resolution processes, such as LCIA arbitration. And they go on to say also there's a public interest in protecting individual personal information and right to privacy, and that the witness statements contain such personal information which should not be disclosed without consent. And so that's their decision, and then they...
So, hold on.
Yes.
We've got to deal with Mr. Clayton's point. Looking at this paragraph,
yes.
Where is the balance conducted with the benefits of disclosure?
Well, had there been some... This is why I place emphasis... I mean, I agree, it isn't.
No.
Straight question to answer, straight answer to His Lordship's straight question. They don't here, in terms, set out what they think are the benefits of disclosure. But one has to approach this with a degree of realism. The person who complains that there has not been consideration of the benefits of disclosure does need to come along to court equipped with a coherent case as to what the benefits are that have been overlooked. It's no good saying, well, they could have, but there were benefits and they should have thought about them. There needs to be a coherent argument as to what the benefits were. And the appellant in the present case has mentioned, we've set it out in the case, has mentioned in passing, and still does somewhat equivocally in his case in this court, mentions in passing the notion that you might get through under the first condition, but my friend, I think, accepts in his oral submissions that we're really in the territory of the second condition, and then it's all put in somewhat amorphous terms, and we've been, perhaps because of that, debating this afternoon what might be possibly to be conceived.
Well, there's a 105-paragraph affidavit, isn't there, from the applicant?
Yes.
Explaining the background in full.
Yes.
To the discontinuance of the public claim against Mr. Jones, and the circumstances.
Yes.
And the political circumstances.
Yes.
And the questions.
Yes.
And the surprises.
Of course, all of that I accept, but I make the point, notwithstanding that it's 105 paragraphs long, what it isn't is targeted on any clear assertion of what the benefits are as to the production of these witness statements. And this comes back to my point, which I won't irritate your lordships by repeating again, that one needs to look closely with, as Lord Steyn used to put it, with an intense focus, really, at the particular facts here, the witness statements. What is it about the witness statements which bears on this general sense of unease which there is said to be, and I don't express any submission about that before the Lordship's board, other than to emphasise Petrotrin's position that it disputes entirely any suggestion that this was anything other than a bona fide decision taken on Council's advice to discontinue the action on the merits, because of its merits. But one has that general, what one can't do in this context, in other words, is to say, well, look, there's a general concern about this whole affair, and therefore we must have any document which happens to relate to it. There does need to be, once one has got to the territory of an exempt document, some decent articulation as to why that exempt document needs in the public interest to be disclosed, and that therefore the admitted public interest in not disclosing it has been overridden.
But isn't that because your clients have put the witness statements into the frame by proffering and disclosing the opinion of Mr. Wilson?
Well, is that because my clients put them in the frame? No, well, inevitably, not inevitably, but frequently, when a public authority discloses some part of a documentary record, that will enable people who read that documentary record to work out that there are other things which the public authority hasn't disclosed. But it doesn't follow that it's in the public interest that all of the rest of it be disclosed. It depends on the particular facts.
At the end of the day, you might say it narrows down to this paragraph on page 717 that you can say with some force, well, if the benefits haven't been clearly articulated, you wouldn't expect the public authority to say very much. But there is no doubt, as you accept, that the public authority in that paragraph concentrates on the damage without recognising any particular benefit at all. And the test for judicial review at the stage which we are considering it is simply arguability. And can one say in the whole context that there isn't an error of law contained in that paragraph, i.e. a failure to balance the benefits or consider what the benefits would be and set them into the balance?
Well, no, I probably have to agree with your Lordship's condensation of the issue before the court. Yes, the question is indeed whether that decision letter discloses an error of law, but in order to get there, one does have to have, in my submission, at least a clear, anyway, your Lordship have the point, a clear articulation of what the public benefits are. I mean, plainly, if it were a straightforward case where there had been a clear articulation in the request, this is the public benefit that I contend will be served by the disclosure of this witness statement, and it had been simply ignored, then it might be said, well, the decision is, on perfectly conventional judicial review principles, defective for failure to consider that. But that's not the case here, because, as I probably overlaid at the point, that hasn't been done. And in that context, one then just turns, in my submission, to...
I'm so sorry, I didn't want to interrupt counsel.
No, not at all.
It might be said that there was a heightened situation here because the decision maker is the very company which would be a defendant if there was a claim over as a result of the wrongful withdrawal of the proceedings, which you said we must concentrate on. So that it might be said, well, there's a heightened difficulty here, and that isn't perhaps so necessary to seek reasonable evidence because there's a clear conflict of interest in the decision maker's side. It may be a party from whom contributions were to be sought in the future, if there were a claim.
Well, I'm not sure that there's any... I'm not sure there's any suggestion, my lady, that there would be any claim against Petrotrin arising out of its having discontinued the action against Mr. Jones. I mean, I don't quite know what your Lordship had in mind by that.
Well, if it was said that the claim should have been pursued, then it would be open to somebody, surely, with the appropriate standing to bring a claim. And this would expose the factual basis.
Conceivably, my lady, but it's a corporation which happens to be owned by the state. I think it would need a relatively creative lawyer to think up a cause of action that anybody would have to sue Petrotrin for its failure to sue Mr. Jones to...
may have a DNO policy. There may be all sorts of reasons. Anyway.
I mean,
but there is a conflict of interest, is the point.
I mean, Lady Hell's point is that this is an unusual application against a party who is the person under potential attack. That's the point, I think, Mr.
Yes.
row.
Yes. But that, my lord, that will commonly be the case in
Well,
information
not
requests.
universally, by any means.
I agree, of course not universally.
No,
Sometimes
no.
it's, sometimes I think of examples. I was looking at a government department that happens to have some documents that a third party has been
Quite.
sending to it, or whatever.
Yeah. Yes, very well.
But yeah, I take your ladyship's point. Of course, it's perhaps more acute when one is concerned with the entity which is said to have been involved. But although in the present context, the real underlying suggestion seems to be not that Petrotrin took the decision, but actually the innuendo, which is more or less spelt out, is that it was the government that took the decision and just prevailed upon Petrotrin to go along with it. So it's not quite the case that Petrotrin itself is directly.
But still, the directors have to consider the interests of the company as a separate legal entity.
But so that's the context for the decision, and the board has seen the judgment of Justice Devine, which is 836. He deals with the matter very much in accordance with the structure of the Judicial Review Act, which is not the way in which it's been argued in the present appeal, but that derives from what is said at paragraph 4, which is that that's the way the applicant, as he was at that stage, put the case. That's page 837. Failure to satisfy or observe conditions of procedure required by law, and so forth. But Lord, I don't have a great deal to say about the decision, other than, which largely speaks for itself, other than that it addresses perfectly fully and comprehensively the case which was advanced before the judge. It sets out absolutely correctly, and this deals really with the first ground of appeal before your Lordship's board. It sets out absolutely correctly what the test is. That's paragraph 15 at page 841. A friend didn't really focus on this in his presentation this morning, but your Lordships will recall that the first ground of appeal is that the judge misapplied the test for permission to proceed, or for leave to proceed with the judicial review claim. But in fact, the judge got it, in my submission, spot on. He asked himself at 15 whether the applicant has satisfied the court that it has an arguable ground for judicial review that has a realistic prospect of success, which is exactly what he ought to have asked himself. There's some suggestion in my friend's case that there is some difference in the test in Trinidad and Tobago as compared to the way in which it was put actually in the Privy Council sitting, the Judicial Committee rather, sitting, I think, on appeal from Trinidad and Tobago in the Sharma case. We set out a note in our case about that at paragraph 29, but to the effect that essentially it's the same, and there isn't a different approach that's taken in Trinidad and Tobago to the approach which was commended by the board in the Sharma case. So, my lord, that suggestion doesn't really get off the ground. The next argument that is raised in terms of the formal grounds of appeal is a failure to have regard to the substance of the appellant's case. This really comes back to territory that I won't go over yet again, to do with really what the appellant's case was and what the relevance of these documents were. I say simply that in the particular circumstances here, the approach that was taken by the decision maker was the right approach to consider whether the public interest override applied, and the judge dealt with that adequately given the way in which it was put. There's a criticism then finally about this reference to evidence of the respondent, but that doesn't take matters any further forward, and I think my own friend accepted, for instance, in his submissions this morning. That's really a slip of the tongue. This is paragraph 29 of the judgment, where it is said that the applicant has not challenged the evidence of the respondent. Of course, the judge was wrong to refer to the evidence of the respondent, strictly speaking, because there was no evidence. We've discussed this already. That doesn't make any difference. And in fact, what the judge is talking about there, in any event, is paragraphs 27 and 28, which is the Section 32 exercise. How do you get to the proposition that these are exempt documents? It's all about the risk being involved in arbitrations of other commercial disputes not being as easy to deal with. So, my Lord, that is the decision of the judge. And just finally picking it up at paragraph 39, the judge says the documents before the court, this is page 847, established that the respondent's designated officer had before him all the relevant information before he responded to the applicant. He considered the fact that the information for the witness statements had been furnished in confidence and that witness statements had been prepared and used in arbitration proceedings. He also considered the rules of the LCIA and the impact on future arbitrations and obtaining evidence from witnesses in future. He also took into account the provisions of section 32 and 35 of the FOIA.
So it does look as though the judge has adopted a classic rationality review approach. Is that right?
My Lord, yes, but that's probably with respect to fair comment. Of course, in circumstances where, as the judge explained at paragraph 4, that is how it was put before him.
Yes, was the argument that has now been majored on, i.e. Lim 2, central to the submissions that were put to Judge Devine?
My Lord, not really.
Reading it, I may have falsely formed the impression that more emphasis was being placed on Lim 1. But,
well, my Lord, yes. If one goes back to, if we go to page 799, which I think should take us to the written submissions before the judge.
yes.
I've got that right. Quite a lot of these very lengthy written submissions are aimed at the a lot of it is general background to the Act and so on. A lot of it is then aimed at the proposition that the arbitration circumstances mean that Section 32 applies. But at 49, which is page 799, we get to this submission. It is submitted that assuming but not admitting that the requested documents are exempt. That was the position at first instance. There is a serious question to be tried, namely whether the exempt document should nevertheless be disclosed in the public interest because there is reasonable evidence of a significant abuse of authority and neglect of the performance of official duty, i.e. the duty to prosecute the claim against Malcolm Jones to recover significant sums of money lost as a result of his breach of fiduciary duty, and negligence. Unauthorised use of public funds, i.e. the monies which Petroleum was forced to pay in legal costs, the damages it had to forego.
Yes, the first 3 bullet points seem to relate to Lim 1, but then
yes.
the final bullet point is the Lim 2 one.
Yes, the final point is Lim 2, but that's really the extent of it in the submissions. And it's perfectly. It's not perhaps relevant now because it's largely been dropped. But I mean, the suggestion that this got within Lim 1, in the respects that are mentioned there, is not one with much prospect on the evidence in my submission. And indeed, the notion that there was a duty to prosecute the claim against Mr. Jones is entirely misplaced, because the duty was to...
Paragraph 71 of these the written submissions, which we find on 809,
yes,
has 9 sub-clauses. The 9th is whether the considerations raised by Petrotrin on the balance can be said to cause prejudice or damage to essential public interest. 2 questions on that. Is that a reference to Section 35? And perhaps more importantly, Mr. Rowe, the reference to essential there, which the learned pleader has taken out of Section 3, essential interests, has that ever figured in either of the judgments below, that they've got to be essential?
I don't think it has been. I don't think it has been, my lord. But that
I don't think it has.
My lord, I don't think it has been. But of course, in the context that we're operating in, it's conceded that this is an exempt document. So really, one is concerned.
We're thinking here about the general obligation under Section 3 to bear the object in mind when construing Section 35. And Mr. Clayton has drawn our attention, as is Mr. Samlal here, at an early stage, to the fact that the public interest invoked by the public authority has to be essential?
Well, my lord, yes and no. Yes, that's referred to in section 3, which talks about the object of the Act. But of course the Act then goes on in specific terms to give effect to that object by making express provision, and doesn't use the term essential. So it wouldn't, in those circumstances, be right simply to read back in to section 35 and section 32 for that matter, the word essential.
But that's why I put to you the first limb of section 3.2, which says you do interpret the Act with reference to the object in 1.
Well, my lord, that...
I mean, and
yes.
Also, standing back a little bit, it would be a bit odd that you only bring yourself within the exempt documents by showing that there's an essential interest, but then suddenly you, the person who has the documents, has a discretion unconstrained by essentialness of protecting the public interest in the Section 35 balance. That would just seem a bit odd, wouldn't it?
Well, the primary duty of the decision maker is I would submit, to follow the terms of the specific provision that is being applied. And once one gets to the stage where the document is exempt, then the test to apply is the general test, if one is not within the first condition, namely whether in the circumstances giving access to the document is justified in the public interest, having regard both to any benefit and to any damage that may arise from doing so.
Forgive me, I thought you'd accepted at an earlier stage in your submissions that there are different degrees of weight to the public interest in confidentiality. So that it's not enough just to say, I'm within Section 32, therefore this is the most essential interest in the world that must be protected against.
No, of course, I accept that. Once, the effect of Section 32 is to switch it round to an inquiry as to whether this is whether the exemption should be overridden. But I accept in those circumstances one is construing the one then needs to construe the Act, bearing in mind everything that appears in the Act as well as just the exact words of Section 35. That's right, but one doesn't, in my submission, need to. One shouldn't place. Or shouldn't further complicate the exercise by saying, well, it can only be where it is, whether there needs to be a separate part of the reasoning that considers whether the public interest is an essential one. But by definition, the scheme of the Act is that by the time you get to 35, under the provisions of the Act, it is an exempt document. And the question then is simply the Section 35 question.
Now, Mr. Rowe, you've got another 6 minutes. Have you got a lot of further ground to cover?
Not a great deal, my lord. I think I'm more or less there. So I think the answer to your lordship's question about...
It seems to me that you must be forcing your point, because the exceptions and exemptions which are provided in the Act must be those which were deemed to be necessary.
Yes.
Essential public interest.
Yes. It's
Yeah. So it doesn't create...
Parliament, as the legislature, has created a scheme whose object is set out in Section 3, but that doesn't mean that you can say, well, Parliament should have created a different scheme in order to give rise to the object, in order to give effect to the object.
Quite. Sorry.
So, my lord, I was picked up on the reference to essential public interest by your lordship, and I hope I've dealt with that. But the point I really take, and the reason I went to these submissions, is to make the point that there is not, in fact, a clear articulation here of what it is that the public interest is, that specific to these witness statements in the particular context requires their disclosure. Then we go to the Court of Appeal, if I may, in the few minutes I've got left. I wanted to look at that because I was really, I think, answering Lord Hodges' question about the way in which the argument was put at first instance. We deal with this in our printed case, incidentally, at paragraphs 15 and following, so 1111 in the page numbering. There was a brief reference in the... I've already said there's no attempt to explain what the reasonable evidence was of the specific first condition mischief, or indeed how it was linked to the witness statements. That point wasn't pursued in the Court of Appeal. Grounds, the grounds of appeals to the Court of Appeal, which I won't go to now, but they're at page 835, they're set out in our case. They refer relevantly only to the second limb, as it were, the second condition. There is, in the written submissions to the Court of Appeal, there is this repetition. This is, I will take your lordship to briefly, 885, reference to the existence of what's said to be a serious question, namely whether the exempt document should be disclosed because there's reasonable evidence of, etc. So it's the same point, really, that was made at first instance. But actually, in oral argument in the Court of Appeal, the appellant was pressed by the Chief Justice to say, well, what is it that you're really relying upon? And that's at 921. Line 17. Which of the four things in section 35, brackets first condition, abuse of authority, injustice, etc., are you relying upon? Mr. Samlal, we're using abuse of authority and neglect in the performance of official duty, as well as D, my lord, unauthorised use of public funds.
Well, have you been entirely fair? Read what Mr. Samlal had said on 917, Mr. Rowe. Line 31. Now, my lord, where we say also the learned judge was wrong is that while we accept the learned judge considered and accepted Section 35 assessment was done by the respondent, where the learned judge fell into error, my lord, was that he failed to conduct himself a balancing exercise as required. And then the Chief Justice says, where is the judgment? So yes. Isn't he there earlier than the bit you just referred to, talking about the balancing exercise?
No, I don't dispute that, my lord. What I was addressing was whether in the submissions of the appellant in the courts below there was any clear articulation of what it was that the witness statements were required, what the public interest was distinctly in the witness statement being disclosed. I agree he makes that criticism there of the judge, but the point I'm on is whether there is anything that is advanced as to the public interest in disclosing the witness statements. And we see at passage your lordship just took me from that he says that's just in relation to the first limb of the Section 35 assessment, my lord. All right, then he refers back to paragraph 65 of our written submissions, which I think is what we just looked at. Yes, it is at 885.
Yes.
So that, I hope, answers the point, that the question that was put to me about how was it put in the courts below. We've set out also in our case what was said in the affidavit. I hope a fair summary at paragraph 23. And it comes ultimately to this suggestion that disclosure of the witness statements would go a long way, I'm quoting, in allaying the fears and suspicions held by the public as to what exactly took place. And your lordship, no doubt, has my point that we submit that it was a reasonable decision to take on the part of Petrotrin, that what went a long way to allaying those suspicions is the production of the advice itself. And it didn't, that requirement did not require, that consideration did not require disclosure of the witness statements themselves. The Court of Appeal give admittedly a very short judgment, but that's in circumstances where they're, of course, acting as a court of review of the first instance judge who has conducted his own consideration of the matter. That's at page 924. They say that the judge has clearly considered himself the Section 35 considerations, which is no doubt a reference to the judge's mention of that in his judgment. And they say, we think the question of confidentiality, this is 924 at line 20, we think the question of confidentiality of the statements in arbitration proceedings is itself a weighty matter when it comes to putting in the scale the public interest consideration with regard to disclosure. Having regard to the fact that by your own agreement we started out from the premise that the documents are prima facie exempt documents, and so therefore in the absence of anything in the way of evidence, as it's opposed to a disquiet or suspicion as to something untoward, we cannot say the judge was plainly wrong. In those circumstances we have to deny your application.
Is it quite right to say the judge has clearly considered himself the Section 35 considerations? When I asked you before, I thought you accepted that actually a fair reading of the judge's judgment was that it was a classic rationality approach looking at the reasoning of Petroleum?
Yes, I did accept that, my lord, and I don't think I can backpedal from that based on what the judge said. But it is right to say that the judge observes that the decision maker took account of Section 35. So it may be right to say that the Court of Appeal were not entirely accurate in saying that the judge himself considered the Section 35 provisions. But of course we come back to my point about whether truly there was anything significant in the balance against Section 35, as to which your lordships are either persuaded by what I have said or you're not.
Mr. Rowe, is that about it?
My lord, that is about it.
Any questions, David? No. We're really grateful to you, Mr. Rowe. Thank you. Now, Mr. Clayton.
My lords, can I just deal with the last point first? I'm afraid that the position isn't part of the way it describes it. There were discussions with the benefit of the Court of Appeal. If you turn to 916, please. Line 4, the main benefit here arose the issues of accountability and transparency, which are very significant because of the allegations being made, particularly as to why Petroleum had withdrawn this matter against the defendant. So that's made clear. Unfortunately, if you go on to read, the Chief Justice then seems to conflate limb 1 with limb 2 because he gets stuck on the question of reasonable apprehension of evidence. It's not helpful. But it certainly is the case that that was flagged up. Turning to the first instance, it's again not right to say that there wasn't a focus on the second limb. My Lord Wilson picked up on the reference to essential interests. If you flick back through to 797, please. You'll see that there's then the quote from it's in fact Justice Damodar's judgment, and you'll see the last sentence. The words essential qualifies both the type of interest and the degree of circumstances that justify the denial of Section 37 override. So the position was made perfectly clear to the first instance judge, and indeed it's also worth pointing to if you go to 794, that the Jamadar judgment, paragraph 41 this is, in the Caribbean Information Access, Section 35 mandates the public authority to consider and override any initial assessment in circumstances giving rise to the access of the document is justified in the public interest, having regard both to any benefit and any damage. So it's perfectly obvious that the case that's advanced before my lords was being advanced at every stage. I will now go backwards to a couple of points just to tidy up, if I may. They are these. My friend sought to draw comfort from Section 23. Sorry, no, forgive me. Actually, I think it was the judicial review section that mandates the remedy being judicial review. Forgive me if I can't immediately recall the section number.
Section 39.
Thank you very much. It doesn't, with the greatest of respect, bear the weight that he suggests. For a number of reasons. The Section 39 does not prescribe the standard of review, partly because Section 5.3 is non-exhaustive, as my Lord Hodge pointed out, partly also, precisely because it is non-exhaustive, there are a range of ways of looking at it, as indeed my Lord Sales pointed out by hypothesizing the proportionality test. Not saying it's directly analogous, but the key point is that it doesn't bear the weight of suggesting it's a rationality test. And it seems, in the end, Mr. Rowe withdrew that rather radical formulation. Turning next to the case he did rely on, the Jug Mohadan case, the new case he handed up. Again, that doesn't really provide my lords with any assistance for a number of reasons. The first is that, as my Lord South pointed out, it isn't a very definitive statement of principle, far in fact quite the reverse. Second, and more importantly, it's a very early case in the High Court decision at that, and it was quoted in the 2019 Maharaj and Port case for the inspection point. It was not cited by the judge in relation to subparagraphs 9, 12, and 13, which are the key ones. If we just go back to 1774, please. 1774. It's volume 2 of the authorities bundle. Oh, no, it isn't. If we go to, yes, 1779, which my Lord Wilson referred to, is a later case, in the Court of Appeal case, and 12, about what's the proper approach to justification for public evaluation and override. It's a cross-reference at 11 to the Joint Consultative Council case.
I'm so sorry,
I've lost
you've
now.
lost me.
What are you referring to?
1774. This is the judgment
Right.
of the first instance judge where he summarizes the relevant principles. And the point I'm making, forgive me, the point I'm making is simply this one, is that when he comes to the Section 35 principles, he doesn't look at the 2006 High Court case to which you've been taken to, but effectively relies either at 9 on a case we haven't shown you, which is a decision of the Court of Appeal, that's footnote 9 on 1773, or he refers to the Joint Consultative Council case that's footnote 11 and the quote from footnote 12. The point is this, that it's the Joint Consultative Council case which is the law in Trinidad presently. And there's lots of different ways one could look at it as to what it means, but I would at least make these points. In our submission, making the balance wrong is an error of law. And we say that really for two reasons. One is because that case, the construction case, I'll call it, refers to a culture and constitutional values and so forth, which is a hard-edged question. And my lords will also remember hard-edged issues. So it looks as if it's a question of law that's been asked. And the cases are determined by asking a factual question. In the circumstances, is on the facts this an exception to the Section 35 override, or is it not? So it does look very like a legal error rather than a rationality error. It may be there's not much between us, but I would certainly make this submission to my lords that it would be premature at this stage for my lords to be beguiled into a conclusion that it's the rationality case that one's dealing with. It's simply premature. The prevailing authority is the Court of Appeal case I've taken it to, and make of it what one likes, but it doesn't get you to Wednesbury rationality. The next point I wanted to turn to was sort of described as part of the facts, but I don't think it really is that Mr. Rowe sought to say that Section 35, Lim 2, derives some sort of flavor as a result of the first limb. With respect, we don't accept that. They are discrete alternatives, and they are separate, and the construction of the limb 2 has nothing to do with limb 1. Mr. Rowe talked at great length about what the benefits and questions about the witness statement. The one thing he avoided doing, and this was with respect, a rather striking fact, is there is a distinction between counsel writing an advice based on witness statements taken in the case at hand and saying, I've looked at the witness statements, there's nothing in this. If that were this case, then I could see there would be question marks about this approach. But that is not this case. The witness statements that was looked at, a point which Mr. Rowe persistently chose not to address you on, were witness statements taken in the arbitration proceedings of 2014. Now, when you come to read it's a relatively short summary, you may find it of assistance to read more than the summary of what the issues are, one struggles to understand how on earth it can be seriously suggested that witness statements in those proceedings could possibly explain a decision to not pursue the claim against Mr. Jones. It's not obvious why, if you have two sets of proceedings and witness statements in one, should be influential or determinative in relation to two. And that obviously raises serious questions. The other point to make, and this was, again, an important point, is you'll remember I took you to passages of the judgment of Justice of the Appeals Barrow and Jamadar about the question of whether there's any point seeing witness statements at all. And it was said by both of those judges that in the freedom of information context, dispelling concerns, showing that people are wrong as well as right, is a sensible and proper basis for making an order. And the suggestion, with the greatest of respect, that Mr. Rowe made throughout, that this was somehow the benefits weren't obvious, is just fanciful. The final point I want to touch on, and this was my fault, I'm going to need to correct this, is I took this too quickly, but I took you through the obvious benefits. But I have now got from Chambers, needless to say, I've changed it slightly, the document which I was reading from, the very conclusion when I tried to identify what the benefits were. Can I just pass that up? These were
yes. Will this put Mr. Rowe in difficulty?
I don't think so, because only to the... I mean, if he wants to say anything, I've finished.
Can you first of all give him a copy?
Of course. And this is not
then,
the final...
Mr. Rowe, you've heard the situation. Are you objecting to our looking at this?
I better read it first, my lord. I don't think so. But, I mean, I'd be surprised if my friend put something objectionable in front of you, but may I have a quick look?
Yes, of course.
Yeah, I should also say I've just...
Please sit down, Mr.
Thank
Clayton.
you, sorry.
Looks at first blush to be a brief written summary of what my friend did say in his submissions earlier. But I mean, if
it's only
your
that,
if your lordship thinks
if it's
that
only
be of
that,
assistance,
I mean, Mr. Clayton, this should have come before. You've got a wonderful team behind you, and how there was an omission to give it to us at the proper stage, I don't quite know.
Well,
but anyway,
I apologise. Partly the problem has been, to a point we haven't touched on, unfortunately, is the papers came late, and they came late.
Oh, indeed.
To my,
don't tell us, Mr.
I know.
Clayton.
I'm afraid
well, we'll look at this.
I'm most grateful. I'm just saying I was slightly disadvantaged as well, that's all. Can I just hand these up? I'm sure there's 8 there.
Well, I certainly don't object to your lordship looking at it. If it might be helpful, then so be it.
Thank you very much indeed, Mr. Rowe.
And
we won't read it now, obviously.
Yeah, can I just say there are a couple of amendments I've made to it. I mean, it won't...
You've got 1.5 minutes. Mr.
Right.
Clayton.
Well, can I just wait till everyone's got a copy?
Yes.
I added under point 2 a new point 3. The Nelson opinion did not object to the disclosure in the High Court. That was an additional point to the one that appears there. That's the early part of the opinion. 5, I added that the waiver of privilege was a weighty factor of the Nelson opinion. And actually, that was it. But that wasn't wholly complete. And I apologize for not doing it sooner, but I didn't.
So does that complete your reply?
It does. Yeah.
Very well.
Thank you very much.
Thank you. Well, the board is extremely grateful to both advocates and not forgetting Mr. Knight and Mr. Stewart and the solicitors, and we'll take time to consider what our judgment will be.